Well, welcome to Elder Law Update 2018. I'm Ron Van Dam, and the expert is, well, he laughed, but he is. He's attorney Roger Levine. He's an elder law attorney. Some people may not be familiar with what elder law actually is. So concisely, what exactly is that?
Well, despite its name, elder law is actually a very new area of law. It's been around since, say, about 1985. It's an extension of estate planning, which goes back to Roman times. You know, the word testament and testes and the rest of that stuff. That's all from the Roman stuff. But I think what happened in the mid-'60s when Medicaid and Medicare passed, and then about 20 years later when there was a lot of people getting older or reaching that age where were affected by Medicaid and Medicare, there was a whole new body of law started coming into being to deal with issues that hadn't come up before. And so in reality, it's maybe 30 years old or so and still evolving to a certain extent. And when people come to see me, the three areas they generally talk about, which I guess consists of elder law, are things about probate concerns, nursing home concerns, estate planning, and estate taxes, which are all things that hopefully we can touch on today.
So these are all items that one would prepare for when they reach the elder part of things, in order to plan for the future to make sure everything's secure and taken care of.
Yeah, well, the estate planning piece is really something that once somebody has kids or property, things like wills and durable powers of attorney that are able to speak for you, if you can't speak for yourself, literally or figuratively, come into play, and that could be something that people do in their 30s and 40s. The elder law piece, generally you're talking about age 65 and up, because that's when the Medicaid and the Medicare laws start affecting. People like me and you, baby boomers, technically we're on the early end of the elder law piece.
I'm only 25.
You're only 25, okay,
so,
but you look marvelous, Mark.
Thank you very much. Now I know, and we've talked so many times before, but I know that things change in the world of elder law, and in the world of everything, things are changing. Federal laws change, state laws change. They constantly have to be updated, I guess.
The laws change. A lot of times, last major law change for elder law was in 2006, actually. There have been some other changes in the probate area. In 2011, they had what's called the Mass Uniform Probate Code came in, which they wanted to implement our probate in the same way as other states, attempting to fix something that wasn't broken. So that's come in. But I think a lot of times what happens is not so much the law changing, but the state situation changing, which means the law will be stricter. Okay, specifically what I'm talking about, two things that I've noticed in the last year is the agency that administers Medicaid. In other words, if somebody goes to a nursing home and they qualify for state assistance, has become a lot tougher to, number one, both get on Medicaid state assistance and stay on it. And I just have to assume that's because it's not that they're bad people down there, but it's a state budget thing. The budget's tight. There's more people in this age group getting older, going into nursing homes. So they sort of have to be very strict about it. So that's definitely an issue that's happening. A lot of chatter there's an elder law group called NALA, National Academy of Elder Law Attorneys. We have our own chat line. A lot of chatter on that line about difficulties that we're having with mass health. That's one thing that's new. Within that area, in terms of documents, irrevocable trusts were something that were useful for protecting real estate. Mass health started making it really hard to accept irrevocable trusts. There were some cases that made it easier, but they're pushing back on that as well. So that's an ongoing struggle there. And the last thing I'll say about changes is with this MUPC, Mass Uniform Probate Code, they put this in effect in 2011. And by about 2014 or 2015, it was, how do I say this nicely? It was so screwed up that they had to readjust, and they put a lot of readjustments in terms of petitions, which took place in 2016 and 2017, which makes the whole probate process a little bit harder. And once again, I have nothing against the people at the Registry of Probate are generally very nice, but they have to deal with the situation that they're presented with. So probates become a little bit tougher because of that. So once again, in these particular situations, it's not so much changes in the law recently, although the probate stuff was 2016 or 17. It's changes in the situation that they have to mold the law, that they have to react to because of it's tougher or tighter or whatever.
Okay, all right. Well, you know, when I think of elder law, the topic, I think of nursing homes because everybody says you got to plan for what could happen, and nursing homes are all over the place now. There's been quite a upsurge in those buildings, and I guess the usage thereof. Yeah. So what's up with the nursing home as far as elder law is concerned?
Well, I mean, people come in to see me and they're saying they've got stuff tangled together in their mind. I got to avoid probate. What's probate? If I avoid probate, I'll avoid a nursing home. If I avoid a nursing home, I'll avoid estate taxes, and they're different things. The thing to know about nursing homes, if somebody has to go to a nursing home, the state doesn't come and take your house and take your money. They just say they're not going to pay for your care unless you financially qualify. And as a spousal couple, you're allowed to have roughly $125,000 for the spouse who's not going to the nursing home and the primary residence. Okay? So until you meet those thresholds, they're just not going to pay for you. They're not going to take stuff, they're just not going to pay for your care. Without getting too convoluted, if a couple is over that amount, there are some things that they can do to convert excess assets into income for the spouse who's not going into the nursing home. So say you're at $300,000, technically you could take a ball at $200,000, convert that to income for the spouse who's not going in, get under the limbo pole of $125,000, and get that spouse qualified. But it's, once again, they're not going to take stuff. It's just that they're not going to pay for your care until you meet those thresholds.
It's a nursing home that'll take the stuff if you don't pay the bill.
Well, it's the state.
Well, okay, fine. Okay. All right.
Basically, if you qualify for Medicaid, the state pays the nursing home the amount over what you pay them.
But if they're not going to pay for you, then that's out of your pocket.
You have to pay privately. Yeah. For a single individual, it's a lot tougher. That person, since you're not protecting it for a spouse who's at home, that person's allowed to have $2,000, and that includes the value of real estate. Mm-hmm. So it's really tough. And if you want to lessen your assets to try to qualify for state assistance because you think you may go into a nursing home, any transfer of assets, whether it be to a life estate, an outright transfer, or an irrevocable trust, has to be done 5 years before you enter the nursing home. Because the state is saying, and maybe rightly so, is that if you're going to transfer assets that could otherwise be used for your assistance, you have to face this penalty period. So that's the story.
That makes sense. I guess the bottom line is people want to keep as much money as they can for their elder years and to pass on to their families. So I guess the name of the game is to have someone help you retain as much as you can and still yet take care of yourself. And this is done through various types of trusts and other things that can be arranged. Mm-hmm. And there are many options available. There are a lot of myths with this, where you hear things, but apparently that's not really necessarily the case.
Yeah, there's a lot of myths, and it's something that affects everybody, eventually passing away. And a lot of times people just don't want to deal with that.
Yes.
But the biggest myths that I found, I'll go over maybe 4 of them. Some of them are, people say, well, I have a living trust. A living trust will protect me from nursing home costs. It's this magic bullet. I mean, a living trust is designed to do certain things. It's helpful to maximize what you can leave estate tax-wise. We'll go over that when we get to the estate tax piece. It's helpful for avoiding probate. We'll go over that when we get to the probate piece. But it's of no benefit for Medicaid or nursing home purposes. Another one is people say, well, I have the Homestead Act on my house, so that will protect my house against, if I go to a nursing home, them taking my house, which is also not the case. Something that you can get at the Registry of Deeds for $37, used to be $10, still a good value, is not going to protect your house against hundreds of thousands of dollars of nursing home liens. It doesn't protect against federal, county, or state liens of any sort. Those are two of the major ones. Is that two or three? Okay. Yeah. The other one is I've already talked a little bit about, which is in the other direction, is that if I go into a nursing home, the state's going to take my house and take my money, which is generally not the case, but if you do some planning, it makes it less likely to be the case. Mm-hmm. And the other thing, which has got nothing to do with anything, but I just happened to think about it when I was thinking about the show, is people talk to me about the reading of the will. I don't know if you remember those old programs.
Yeah, they were great. They're fun.
Everybody was in the room, and some stodgy old lawyer came in and says, well, I leave everything to my nephew, and 3 people faint, and the nephew jumps up and down. That doesn't happen. Oh. I've been doing this for over 20 years. We've never had a situation like that. Usually people know what the situation is, and hopefully they know. Sometimes there are some surprises, but that sequence in that room never happens. It's good. I was looking forward to it. Unfortunately, it just doesn't happen.
That's too bad. Let's talk about probate. You use that word a few times, and some people may not know exactly what that is. The basic bones that most lay people know is that you prepare a will, and it's read, and you get it, and you go home. It's certainly not that simple. And what happens if you don't have a will?
Well, here's the deal. I mean, this is once again, a misconception. If I have a will, I avoid probate. Mm-hmm. That's not the case. Probate does involve wills, but probate is not based on whether you have a will or not. Probate is based on whether you die with an asset in your name alone or not.
For example?
For example, and this is a common one, say a husband and wife. Husband and wife, for example, generally have a joint account, so if one dies, it's not in that person's name alone. Mm-hmm. It goes to the survivor, or they're the named beneficiary. But when the second spouse dies, often, especially for houses, it's in that person's name alone. It goes through probate. Probate, in 25 words or less, is anything that somebody dies with in their name alone has to go through a court process. If you have a will, eventually, hopefully, it'll pass by the terms of the will. If you don't have a will, it'll pass by an intestate formula. So it's certainly always better to have a will than not have a will, but it's not, well, I have a will and I avoid probate. It doesn't work like that. It's whether an asset is in your name alone or not. In reality, many, if not most assets don't pass by probate and don't pass by will. I'm always hesitant to say, well, people say, well, then I don't need a will. All right, there's 3 other methods that assets generally pass by. So I don't mean to do a monologue, but let me just get this out there. All right, if you have a joint account with somebody, say 2 spouses, and one spouse dies, doesn't go through probate, automatically goes to the surviving spouse, only goes to probate if the second spouse dies with no joint owner. The caveat that I always give people about joint accounts is it's okay for spouses to have joint accounts because they each protect each other from each other's creditors. I'm a little wary about having joint accounts with kids because you don't have that protection. So if the kid has a problem, the money in that joint account is available to the kid's creditors or the kid's malfeasance. So I would just give that caution. The second way that assets pass, people have IRAs, they have 401ks, they have life insurance policies. In almost all of those situations, when you set up the policy, you write down the named beneficiary. Okay, so if you pass away and your wife is your named beneficiary, then there's no probate. The court doesn't say where does it go. It says right here on the beneficiary card that it goes to the spouse. There's another caveat that I give people with that. It's something we do a life insurance policy in our 30s or 40s. We take out an IRA in the 30s and 40s, and we don't think about it again for the next 40 or 50 years. Well, what happens if your beneficiary has passed away? Guess what? In essence, that's in your name alone, has to go through probate. Or what happens if your beneficiary, say your beneficiary is your son, and you had a falling out with the son and you haven't talked with him for 30 years. Guess what? If he's still on the beneficiary card, he's going to get those assets. Mm-hmm. So once again, just like joint accounts, where I encourage transfer on death or payable upon death accounts instead of that, on these IRAs and life insurance, which are transfer on death or payable upon death accounts, make sure the beneficiaries that you have are, number one, still alive, and still the ones that you want to get it. I advise people to check their beneficiary cards and their beneficiary designations once every 3 to 5 years, and I think that would do the trick. So the final method of how things pass is if you have a trust and you actually fund the trust, you put the asset in the trust, that'll avoid probate. Why? Because the asset's not in your name alone, it's in the name of the trust. A lot of now with real estate, for example, to fund a trust, you literally do a deed. Ron Van Dam, deed to the Ron Van Dam Trust. That gets recorded at the Bristol Registry of Deeds. So when you pass away, it's not in your name alone, it's in the name of the trust, and your kids take title and they can sell the house. With things like bank accounts, it's actually pretty simple to do. If you have a bank account with just your name, and you have a trust, the way to put it into the trust is you literally get a card from the bank that says, who's the new owner? Oh, the new owner is the Ron Van Dam Trust. Mm-hmm. Okay, so once again, if Ron's not with us any longer, sorry to kill you off here, Ron.
Yeah, I know.
If Ron's not with us any longer, it doesn't go through probate because it's in Ron's trust because he's changed the bank card. Mm-hmm. The thing with living trust that makes me crazy is people say, well, I have this living trust that does everything, and they never fund it. So you may have a living trust, but if nothing's in it, it's as if you didn't have it. So living trust will avoid probate if you actually fund the trust in those ways. And the final way is if an asset is in your name alone, if you have a will, it'll pass by the terms of the will, eventually going through probate. Mm-hmm. If you don't have a will, it's an intestate formula, state distribution, which means we hope you like your next of kin because that's where it's going.
Okay. And just to clarify, probate is as a court hearing type of situation.
Yeah, it's a court
deal.
process. Yeah, with judges and petitions and the rest. Hopefully, with no judges. I mean, usually there's ultimately a judge involved. But if the people aren't fighting, it's basically a court process.
Right. Okay. All right. So we got all that done. And thanks for all those tips, by the way.
Okay.
If I wasn't stuck here,
you got to rush out after the program.
And I'm going to change all my checking accounts and put it in the name of myself.
Okay, there you go. And put it in the name of yourself.
Somebody else.
To ensure that you go through probate.
You know, you said something interesting to be wary of putting kids on a joint account for that reason. And I'm thinking, they could take the money out for something. And then you said something very interesting. Creditors can actually use
saying
that.
It's not so much kid. I mean, there is potential for kids malfeasance, but if the kid goes bankrupt or divorced, those are available assets.
Very feasible, very possible.
And people say, well, I have him on there so he or she can write checks for me, make it convenient. Well, there are other ways to accomplish that. If you have, we'll talk about it a little bit later, durable power of attorney gives them the authority to act for you financially. Okay. So you don't need to do that for that purpose.
All right, let's talk about estate taxes, what that actually is, how it may affect some people and other people not really at all, and the fact that the threshold, the amount of estate taxes, that changes on a regular basis, really, depending on who the president is, pretty much.
It has the potential to change on a regular basis.
It can.
Well, here's the thing about estate taxes. Number one, for most people, it's something they worry about and they shouldn't. And the federal level is something they worry about and shouldn't. I mean, right now it's $5 million. Republican administration, they'll abolish it altogether. Democratic administration, maybe it gets knocked down to 3, 2, who knows. But what's important for our purposes, because in Massachusetts you have state estate taxes. And that's the thing that a lot of people are caught up in. But those are still high. For most people,
what is the threshold right now?
The state estate tax threshold is $1 million and has been forever. It's been and people talk about, well, it's going to change, it's going to go up, it's go down. I don't know of anything. I haven't heard any talk that it's going to change. So we're going to assume it's $1 million. Now, for most people, if you have 2 spouses and the totality of what you have is less than $1 million, including the value of your real estate, including the value of your IRAs, life insurance policies, everything, then you really don't need to worry about estate taxes. In other words, if one spouse dies and everything goes to the second spouse, the whole ball of wax, as I call it, and that second spouse is still below $1 million, there's no estate taxes. All right. But if you're over $1 million, there are estate taxes for the amount that's over $1 million, and that generally runs about 15% of the amount that's over $1 million. Now, one of the useful things for living trusts, as well as avoiding probate, if it's funded, real estate put in it or bank accounts put into it, is that a husband and wife can actually double the amount that they leave estate tax free, but it doesn't happen automatically. It's usually done with separate living trusts where assets can be split. So when the first spouse deceases, that you either have or can get into that spouse's trust up to $1 million, which means, say if a couple has $1.8 million between the value of real estate, IRAs, life insurance, whatever, if they have $1.8 million, when the first spouse dies, if you're able to either have $800,000 in the deceasing spouse's trust or be able to get it in there, which you can do with real estate, which means the second spouse, even though he or she has access to that $800,000, when the second spouse dies, that spouse only has $1 million. That $1 million comes down estate tax free. The $800,000 being held by the first spouse's trust, even though it's accessible to the second spouse, comes down estate tax free. And so you've managed to pass on way more than $1 million.
But somewhere down the line, you're going to have to face that estate tax.
No.
If the remaining spouse passes,
right, with $1 million in
right,
estate taxes,
right,
and the $800,000 that's been put into the trust of the first deceasing spouse,
okay,
that when the second spouse deceases,
well,
that $800,000 comes down under the first spouse's name.
Right.
I mean, if it's done right, you can do it. It's not that tough to do. It's a little bit easier to do with real estate because you can assign the value of the real estate to the first deceasing spouse's estate. So that's one of the techniques that we use. The other thing I'll say about estate taxes, and people get two things. People get estate taxes mixed up with capital gains taxes, and capital gains is just a gain that you make in a particular year. That's really an accounting thing. It's got nothing to do with estate taxes. And people talk about the $10,000 a year gift that you can do, which is actually $14,000 a year. And it only makes sense to do that if you have a taxable estate. And you can gift up to $14,000 a year to as many people as you want. Each spouse can gift up to $14,000. Say you're at $1.2 million and you want to go below estate taxes and you have 3 kids. You could gift, each spouse could gift $42,000 a year. That's what, $84,000 a year. Within 2 or 3 years, you've knocked your estate down.
To lower your assets so
lower
that
your
you're
assets without lowering the estate tax cap.
Right.
So that's one thing that people can do. And people talk about doing that for nursing home purposes, but that doesn't work. It's still a transfer of assets. So people say, well, my mother's going into a nursing home. I understand that she can gift as many people as she wants $14,000 a year. Well, that's true. Number one, if she's going into a nursing home and she's well below that threshold, the idea of gifting doesn't make sense because you're not doing it to avoid estate taxes. And number two, that's still a transfer of assets. So you can't do last-minute gifting if somebody's going into a nursing home like that. And that's a very common misconception.
Okay. That still falls under that 5-year look-ahead.
Yeah, basically any assets that you transfer out of your name have to be out of there for 5 years before they're not really considered your assets. Just in terms of protecting real estate, people say, well, I'll put my house in a trust. That'll protect the house. There's about 5 things you can do with real estate, only 2 of which work for nursing home purposes. Okay. People talk about putting their kids on as joint owners, which we never do because, once again, just like that, if a kid has a problem, you could lose the house.
Yes. All right, we're down to about 5 minutes.
Oh, a 5-minute warning.
Yeah.
Okay.
But I did want to cover this because I've talked to you so many times about this on TV and interviews. People do not think about doing their last will and testament. Okay. And there's really no reason that they wouldn't, but like you said earlier, it's like facing the subject head on or avoiding it. And if you do face it, then you can actually plan quite painlessly.
Yeah, I mean, the old saying, what's the trite old saying, which is true? It is better to have these things and not need them than to need them and not have them. Because that's when you end up in probate court for guardianships and conservatorships and probate. So generally what I recommend is what I call core estate planning documents. And there's a couple of other documents, if we have time, I'd like to just briefly touch on. There's 5 core documents, 2 that are financially based, 3 that are medically based. Financially based will, if you die, will basically says, this is where I want my stuff to go. If there are assets in your name alone, that's a way of making sure that they get there. It lets people know your intentions. If a person becomes legally disabled and can't make financial decisions, somebody else can't automatically do that for him or her, even if it's a spouse. You got to go to probate court and get what's called a conservatorship. All right, there's a simple document called a durable power of attorney, which basically says, hey, I appoint my husband and my wife to make these financial decisions. If I can't do it, and if they're not with us, I appoint my son, my daughter, my son and my daughter. So once again, that would take care of the need to have to go to probate court and do a conservatorship. The 3 medically based documents are like the durable power of attorney and go hand in hand. Healthcare proxy is a legal appointment of an agent. Without a valid healthcare proxy in Massachusetts, somebody would have to go to probate court and get what's called a guardianship. In Massachusetts, just because you have a healthcare proxy, the medical institution doesn't have to act in any particular fashion. Companion documents called a living will, which is a statement from you yourself that if you're vegetative comatose, no chance of recovery, that you wouldn't want to be kept alive automatically. Going back to that case in Florida, Terry Schiavo, what the story was, she had a healthcare proxy naming the husband, but she had no living will. So the medical institution said, fine, we see you're the agent, but where does it say this is what she wants to do? And that's why that was such an ordeal, and that's why those documents go together. As if that wasn't enough, the federal government passed something called HIPAA, Health Insurance Portability and Privacy Act, which had to do with the privacy of medical records. So now medical institutions are hesitant to give records to agents because they're afraid they're going to violate these privacy provisions. So now we do a HIPAA release that says, hey, if my agent needs access to my records, I'm aware of HIPAA and I'm authorizing him or her to have access to those records. Between those 5 documents, there's virtually no situation that can come up if you pass away, you become legally disabled, that you haven't pre-spoken for. A couple of other things I want to mention briefly. I don't know, how are we doing for time?
I think 2 minutes.
2-minute warning. 2 minutes. I say we kick the field goal.
All right, go for it, Ben.
All right. I want to mention protection of the real estate. Somebody has to go to a nursing home, which I started talking about. Living trusts, don't do it. Anything in a living trust is completely available to nursing home as a countable asset. Irrevocable trust can do it if it's written the right way. Problem is you have to cede a lot of control of the irrevocable trust. You have to make sure that you stay at for 5 years, and you can, if you sell the house, to protect that money, you can't have access to the principal. You can only have access to the income. The most common thing we do is something called a life estate, which divides the ownership between a current owner, usually a parent or parents, and a kid or kids who are future owners. They don't have a current interest like a joint account, so if they have a problem, it shouldn't affect them. They do have a future interest, so if you decide to do something, you're going to need their okay. As long as you have their okay, there's generally no downside to life estates. Life estates do pick up 5-year disqualification periods, but unlike irrevocable trust, if you don't make the 5 years, you can always reverse a life estate, and you haven't lost anything, and you just haven't gained what you otherwise would have.
There's a lot to take in. The bottom line is, if you haven't done anything, do something. Seek out an expert, because there are so many different. In other words, don't make a mistake when it comes to this kind of stuff.
The purpose of this program is just to give a broad overview of some of the issues, and hopefully this information will be helpful.
And it's a little bit of get things done. You know what I'm saying? He's attorney Roger Levine, elder law attorney, specializing in that. Thanks for all that information.
All right, thanks for having me, Ron.
And thank you very much.